How about drafting an MOU bill? The state of California is required to negotiate a memorandum of understanding for all of its public employee bargaining units. And this area of the law is set forth in Government Code Title 1, Division 4, Chapter 10.3, which is titled State Employer Employee Relations. And it covers Government Code sections 3512 to 3524. Government Code Section 3517 requires the governor or his or her representative, as is designated by law, to meet and confer in good faith regarding wages, hours, and other terms and conditions of employment with representatives of recognized employee organizations, as well as to consider fully presentations that are made by the employee organization on behalf of its members prior to arriving at a determination of policy or a course of action. And the phrase meet and confer in good faith is defined in this section 3517. Government Code Section 3517.5 requires that if an agreement is reached, the governor and the recognized employee organization will jointly prepare a written memorandum of understanding, an MOU, which must be presented to the legislature for determination. And as a result of this code section, the legislature approves each MOU after it has been negotiated by the executive branch. Also relevant is Government Code Section 3517.63, which provides that any side letter, appendix, or other addendum to a properly drafted MOU that requires the expenditure of $250,000 or more in related salary and benefits, and that's not already contained in the original MOU or the Budget Act, is also required to be provided by the Department of Human Resources, CalHR, to the JLBC, the Joint Legislative Budget Committee. Thereafter, the JLBC is required to determine within 30 days after receiving that side letter, appendix, or other addendum if there are substantial additions that are not reasonably within the parameters of the original memorandum of understanding, and it requires legislative action to ratify that side letter, appendix, or other addendum. In addition to those items, the CalHR has to incorporate in any subsequent MOUs submitted to the legislature for approval those types of side letters, appendices, or other addenda. Finally, to be aware of is section 3517.7 of the government code that specifies that if the legislature does not approve or fully fund any provision of the MOU, which requires the expenditure of funds, then either party may reopen negotiations on all or part of the MOU. And the parties are not prevented from agreeing and affecting those provisions of the MOU which have received legislative approval or those provisions which do not require legislative action. Also be aware that the Senate rules contain Senate Rule 29.4 concerning bills approving memoranda of understanding. And Senate Rule 29.4 provides the following. The Senate may not pass a bill that approves a memorandum of understanding until the final version of the subject memorandum of understanding is received by the Secretary of the Senate and made available for review for 7 legislative days. And its availability for review is noted in the Senate Daily Journal for that 7 legislative day period. Now, in terms of the bill language for a bill that would be used by the legislature to adopt the MOU, the following, I'm going to read some of the sample language that's likely to appear in an MOU approval bill. The legislature finds and declares that the purpose of this act is to approve and make the conforming statutory changes for the agreement entered into by the state employer and state bargaining unit, whatever it is, pursuant to section 3517.5 of the government code. Another likely provision is notwithstanding section 19829.5 of the government code, The provisions of the addendum prepared pursuant to section 3517.5 of the Government Code and entered into by the state employer and the state bargaining unit, and the date, the name of the state bargaining unit and the date, and that require the expenditure of funds is hereby approved for purposes of section 3517.63 of the Government Code. Another likely provision reads as follows. The provisions of the addendum included in section whatever of this particular act, this bill, that require the expenditure of funds shall not take effect unless funds for these provisions are specifically appropriated by the legislature. If funds for these provisions are not specifically appropriated by the legislature, either the state employer or the state bargaining unit may reopen negotiations on all or part of the addendum. Another sample provision that's in most MOU bills, notwithstanding section 3517.63 of the Government Code, the provisions of the addendum included in the section of this act that require the expenditures of funds shall become effective even if the provisions of the addendum are approved by the legislature in legislation other than the Annual Budget Act. And then usually there's an appropriation. And so that'll read like the sum of blank amount is hereby appropriated for state bargaining unit number, fill that in, for expenditure in the next fiscal year in augmentation of and for the purpose of state employee compensation as provided in line item blank of section blank of the Budget Act. So the MOU bill will likely amend several sections of the Government Code that specifically reference different MOUs with the number of state bargaining units. And then the bill is put before the both houses of the California Legislature for an ultimate up or down vote. It requires a majority vote of both houses unless the MOU includes an urgency clause, which sometimes they do, so that the measure would take effect immediately upon enactment.